Good morning. This is case number 25-3078FY. Mr. Wright, you're here for a PCC. We received notice yesterday. They still have not found an attorney for you. However, they have sent it to the Michigan Special Assignments team, and they're hoping to get somebody soon. So what I'm going to do, instead of having you keep coming back, I'm going to adjourn this for 2 weeks, and hopefully that will be enough time for everybody to hopefully to get you an attorney lined up. All right. So just a reminder that your bond conditions continue, and you can go out to the front window where you checked in and get your next court date.
Thank you.
All right. Thank you. All right. Appearances counsel, starting with the prosecutor.
On behalf of the people. Your Honor, Harry Mihas on behalf of Mr. Bartholomew.
Good morning, Your Honor. Nicole Smith on behalf of Mr. Bartholomew.
Good morning, Your Honor. Tracy Deinhardt on behalf of Ms. Bartholomew, who is present and seated to my right.
Good afternoon, Your Honor. Sarah Valenti on behalf of Ms. Bartholomew.
All right. Thank you. You all may be seated. So we are here for a probable cause conference. It's my understanding there is not a resolution in this matter. Is that correct, counsel? In these matters, I should say. All right, then I'll turn to the defense. Anything for the record?
Your Honor, we need to address discovery. At this point, discovery is being held hostage. We have not received one piece of paper, not one. The only thing that's been revealed to us was the probable cause affidavit, which was released previously to social media before it was released to us. We have attempted to negotiate with the Attorney General. It's our information and belief that the Attorney General's office is in charge of disseminating discovery. They are insisting on an unacceptable discovery protective order that does not fit what we're doing here and interferes with our ability to conduct a defense and ensure our client's rights. At this point, Your Honor, we're dumbfounded what to do when the whole point of this conference was to have everything and to just blow off the court's authority to not give one piece of paper, knowing that, understanding that while our clients are confined without a bond, it's unacceptable, it's unethical, and it should be sanctioned.
Your Honor, I share in the comments of Ms. Mihas or Mr. Mihas in this case. I have also not received a single document, whether it be a autopsy report, a police report. I've received absolutely nothing beyond the probable cause affidavit that was released. My understanding is to the media prior to the first probable cause hearing in this case. In fact, I received that affidavit when I opened up my own Facebook page and read it on Facebook, which quite frankly is unacceptable. At this point in time, my client continues to sit incarcerated, held without bond. If the government is not prepared to move forward with this case never should have been charged back in December when it was charged. At this point, I share the comments of Mr. Mihas. I'm asking for either this case to be dismissed if the state is not prepared to move forward with this prosecution, which at this point in time, without a single piece of discovery, and the probable cause affidavit is not discovery. Without a single piece of discovery, the state is not prepared to move forward. So yes, I am asking for this case to either be dismissed, or I'm asking for my client to receive a bond in this case pursuant to the court rules. She's been incarcerated long past the 30 days that this hearing was adjourned to allow for the discovery to be turned over. Your Honor, it's my understanding that the Attorney General's office is the one handling the discovery. And I will note for the record, the Attorney General's office or a representative is not in this courtroom today. Quite frankly, if the court is not inclined to dismiss or grant a bond in this case, I would ask for the Attorney General's office to be show cause to explain why discovery has not been turned over to the defense at this time, to explain the violation of due process in this case.
Your given statements, I want to quote from an email sent January 9th, 2026. We don't have full discovery as it's still ongoing in the investigation stage, but I do believe we will have some documents.
And that's from
Melissa Palka from the
the
AG's
AG's
office.
office.
If it's still being investigated, why was my client charged? Why was Ms. Bartholomew charged? If we're still investigating, which again, Mr. Bartholomew needs bond at that. We've passed the 21 days. We were told, be ready, have everything out, or let's dismiss, because if you're investigating, investigate all you want, but my client should not be held in that.
And when did you each follow your demands for discovery?
I filed my appearance and demands immediately. I believe it was December 2nd or 3rd. So the 21 days to follow through with the discovery request, it's in blatant violation at this point. I've been told numerous times that I would have discovery, and I don't have discovery. I will also note for the record that it's my understanding Ms. Palapu has filed an appearance in this matter as a second chair or co-counsel with Ms. Curie. So again, I do not understand why the Attorney General's office is not currently here to explain why we do not have the discovery if it is the Attorney General's office that is handling the discovery in this matter.
And it's my understanding that they want to release what they have so far under a protective order that
Your
your
Honor,
parties haven't come to terms with yet.
to discuss the protective order in their email, which I have, and I will admit it as an exhibit.
I would actually ask that that be marked as an exhibit in both
So
files.
it's exhibit. She indicates that they are using a template from a child endangerment and human trafficking unit. Your Honor, this is a murder. And the template, and I referred to this briefly in my opening statement, the template dives into requiring us to reveal our defense, who we're going to use that might see the discovery. That is unheard of in a murder case. We have offered to negotiate. We have said that when it comes to medical records and any reference to any children, we will agree to a protection order, not a problem. But when it comes to the information regarding the murder, police reports, case law is very clear. We are entitled to it now. And so when we get a flippant response saying, I don't know if I have 100 pages or 100 files, 100 reports, you do know. The AG's office took this case on, became a part of it, has gone public, said we're in. They are assigned to our knowledge to deal with discovery. Wexford County is not. They have an entire unit that deals with discovery. They certainly have the resources, and to not have a piece of paper divulged and to come at us sarcastically when we're trying to get something done and our clients are being held in jail with no bond. Unacceptable. Absolutely unacceptable.
Your Honor, I will also note that as part of that protective order, when the defense indicated, as the email references, that we weren't going to sign that protective order, we were told, fine, then we will slow roll the discovery in a redacted format, which that does not comport with the law. The defense is not entitled to redacted discovery. And in light of the fact that the probable cause affidavit was released unredacted to the public, that's an even bigger problem.
One last note, Your Honor, and my partner reminded me. Materials are already ready from the state police and Wexford County through FOIA. We have been quoted a price on social media. Social media activists have been quoted a price for FOIA release of the documents we're seeking here.
And that's FOIA requests to the county and the state?
Yes.
State police.
That is our understanding.
And so if it's ready for FOIA, stop playing games. Please stop playing games with our clients' lives.
Thank you. Mr. Carnes, anything in response?
Thank you. Just to clarify, on Friday, January 9th, AG Palapu sent the email, okay, no problem, we will redact the police reports and get them to you. I will let you know anything that wasn't provided and why. We will let you know when the discovery becomes available. I think the discovery will be available soon. Again, this was sent on Friday. It's now Tuesday. It was a weekend. I think there are issues to be ironed out as far as the protective order. That's something I think we can all work on, but to assume that the AG's office has essentially dug in their heels based on one email response, I think is not appropriate. So I'll leave it to the court's discretion as to whether to set a show cause regarding discovery. I would ask for the defendants to remain held without bond. Very serious case, very serious allegations, and we will be working to get discovery released as soon as possible.
Do you know when your office started receiving discovery
I think it was
or discoverable
Thursday or
material?
Friday of last week.
That's when you started receiving it?
I believe so.
And are you receiving it simultaneously with the AG's office?
I think the AG's office is actually receiving it through us.
So you're receiving it and then sending it to the AG's?
Digitizing it, getting it to them is my best bet, but I would need our discovery clerk up here to know for certain how that's working.
Yeah, may I approach? I want to enter this as an exhibit.
Yes.
Again, for the record, Your Honor, I would ask that this exhibit be marked as a joint exhibit between the two files, please.
Yes.
No objection by the people.
Your Honor, the one thing I would know that my colleague has said, we're entitled to unredacted. There is no need to slow roll this through a process of redaction when case law is very clear. In this case, we should get unredacted, and we're more than willing to agree to protective orders when it comes to medical records, HIPAA, and any kind of child interviews, child picture, things like that.
Assuming they exist.
Correct. Mr. Carnes, I know you're not necessarily assigned to this case, but do you know, are there still pieces of discovery that, or reports, things like that, that you haven't received yet?
I would say it is likely that that is the case, but I don't know for sure. I would also say that's pretty normal that we would have enough probable cause to hold people while facets of the investigation are still ongoing. And I don't think anyone has used the word slow roll in discovery. I think all parties are working to get discovery released.
I'll state for the record, defendants A is received without objection. Give me a moment to look at that real quick. All right. Anything else from anybody? All right. What the court is going to do is I'm going to set this matter for a show cause with both the Wexford County Prosecutor's Office and the Attorney General's Office to see why discovery has not been complied with pursuant to the 21 days provided by court rule. I do understand the argument that defense is making regarding bond. I also understand the complexities of this case. However, it has been going on for a month, and it sounds like there is information out there that the defense certainly is entitled to. I will make a determination regarding what we're going to do with the case or bond after we have the show cause regarding discovery. Is it possible to set a date for that now?
Can we just, it'd be easier to work calendars.
I'm sorry.
Setting the
date.
Yes.
Yeah, probably that would work better.
We could do 30.
What time? Anytime.
We could do morning.
Will the morning of the 30th work for everybody?
That would work for me. Karen. We'll make
I'll make it work, Your Honor.
All right,
What time?
let's do 10 o'clock. Anything else for the record, counsel?
Nothing, Your Honor. Thank you.
All right, thank you.
Thank you. Your Honor.
Thank you.
Thank you, Your Honor.